Good afternoon, everybody, and welcome. Thanks so much for joining us. It's a real pleasure that we've got so many attendees already for this webinar. I always try to look on the bright side of this pandemic, and I think it's things like this where we've got more people joining than we would actually have in person if we were holding this session in our office. So thank you very much for your time. This session forms part of the Brexit Spotlight for our newly launched 1000 Digital Thought Leadership Series. And this focuses on key issues, historic moments, or pivotal changes that will affect our clients. So other recent and current spotlight topics include, of course, the global pandemic, the US election, and IBOR. We'll be hosting our next session on Brexit, in fact, tomorrow, and we'll be looking at the fate of immigration in 2021, and you will find details of how to join that session on our 10100 webpage. In the meantime, thank you again for joining, and I hope you enjoyed today's session, which really does showcase the strength and depth of Mayer Brown's knowledge and expertise in this critical area for businesses. So with that, I'll hand back to you, David. Thank you very much.
Thank you, Sally. We're now less than a month from the end of the Brexit transition period. The United Kingdom and the European Union have been locked in torturous negotiations for a year over the future relationship. And yet, we still don't know the basis on which UK businesses will deal with their counterparts in the EU, and neither of them know the terms on which they will access each other's markets from the 1st of January. There have been false dawns, and there might yet be an agreement this week, or perhaps next week at the EU summit on the 10th of December, with all parties claiming victory the following morning. But it's also possible that an agreement will just prove too elusive, and that we will find ourselves on the 1st of January relying on World Trade Organization terms for trade with our largest partner. Last week, a leaked Cabinet Office briefing reported that the UK faced a systemic crisis and economic chaos with a high degree of change, regardless of the outcome of the negotiations, when combined with other issues including COVID. The main outstanding point of difference appears to relate to rights to fish in British waters, along with concerns of the EU to ensure a so-called level playing field with the UK. It seems extraordinary that these issues could prevent a deal with so much at stake, but in fact they're emblematic of deeply held feelings, on the one hand, about a commitment to a kind of sovereignty, a concept of sovereignty in the UK, and about the EU, a commitment to preserving at all costs the integrity of the EU single market. Philosophical differences aside, time is rapidly running out, and without an agreement from the beginning of next year, the UK will have no access to the EU's energy markets. There'll be no agreement on police and security and judicial cooperation, and the separate EU decision on which financial services can be sold within the EU from the UK may well be compromised. And this is not to mention the potential for practical difficulties arising, for example, in the case of supply chains. Last week, or last month, in fact, the chief of the port of Calais told the House of Lords that French border officials would make life so difficult for lorry drivers that they would never forget the correct papers ever again. Nevertheless, amid the uncertainty, some things are clear, and consistent with the 1000 theme that Sally mentioned, I have, in fact, 10 points, which are quite brief, which you will see on the slide, and we'll illustrate these by reference to a case study in a moment. So first, the choice at this point is between a hard and a very hard Brexit. This means that a lot will be left out of whatever agreement is ultimately agreed upon, is agreed, and there will be considerable uncertainty. One aspect, a key aspect, I think, of a free trade agreement would be that it would create goodwill and it would create a basis for future agreements. But nevertheless, it would only be a partial solution. So trade will be covered by it, security will be covered by it, and there'll be provisions on the so-called level playing field in relation to areas such as employment and the environment. But it won't cover financial services. That is, as I said, the subject of a separate discussion and a separate equivalence decision, ultimately, we hope. There is talk of a temporary separate services agreement, but that would probably require ratification by member states and could only happen after the new year. That may of itself not be straightforward. And fourth, much EU law, in fact, will no longer be applicable in the UK in areas such as intellectual property and data security, but a lot of EU law will be still applicable in the form of what is called retained EU law. Now, quite how much EU law will depend on whether we have a free trade agreement, and nobody really knows outside the negotiating parties what will be in it. And there are some fairly complex provisions in any area that you look at that deal with the interplay between the legal systems. There's also a notion of divergence, and the UK has, in fact, stated that it's going to produce some regulations which would, as the government put it, help achieve our aim of enabling retained EU case law to evolve more quickly than otherwise might have been achieved. So this is, in fact, going to involve pushing down the ability to the Court of Appeal from the Supreme Court to depart from EU case law. Fifth on my list here, there wouldn't, of course, be a complete legal vacuum if we don't have a free trade agreement. There is the withdrawal agreement and there is the Northern Ireland Protocol, both of which contain certain commitments. And, of course, there is the World Trade Organization regime. Sixth, there is scope within all of this for some new UK policy approaches. And there'll be some fairly significant changes in areas such as agriculture. There's the possibility of a gradual evolution in areas such as competition. And state aid, as I say, has become a totemic issue, the point of principle in the discussion now, but the possibility remains that the UK might adopt a state aid policy which is slightly different to that of the EU, certainly in the absence of a trade agreement. Eighth on the list, compliance risks. Whatever the outcome, businesses will have to adapt to a fairly labyrinthine new regime, whichever area you look at. One of our clients mentioned to us that they thought they were very well prepared, and indeed were, but they then discovered that the pallets on which they shipped their products were not going to be compliant with certain EU regulations. And the enforcement climate, which will be to a large extent down to national authorities, may well be uncertain and discretionary in many areas. Eighth, I think it has to be assumed that there will be disputes between private parties arising out of all of these changes, and different legal mechanisms to those that currently apply, and EU legal order will have to be invoked. Ninth on the list is this strange new term, EU relations law, which is really an area that's attracting a lot of scrutiny by lawyers at the moment, in terms of, for example, how the relationship between the EU and the UK is to be interpreted in the future, how are the legal relationships capable of being modified, what legal rights arise, what are the roles of the UK and the European courts respectively. That, I think, will keep a lot of lawyers very busy for a long time. And finally, if all of this were not enough, there is talk of review clauses. So whole new areas could be, over time, reopened. So over the next 50 minutes or so, we'll illustrate some of these points by reference to a simple case study. This is based on a hypothetical UK car manufacturer, Speedico. Speedico produces luxury passenger cars and exports them from the UK to the EU. It's part of a large international group, and it also has component parts in some other EU member states. So Jason is going to talk firstly about the trade-related issues that arise. Thank you, Jason.
Great, thank you, David. So from in the next few minutes, we'll talk about how Speedico will find its trading landscape changed from a few perspectives. One, at the UK border. Two, coping with export controls, and three, economic sanctions. We've all heard about the lorry parks in Kent, which I think are in strong contrast with what the early rhetoric was about frictionless trade. However, that ultimately turns out the procedures for importing and exporting will change in the UK from the 1st of January. Although on the import side will change in stages. So from the 1st of January, goods coming into the UK from the EU will be subject to the same import procedures as goods coming in from anywhere else. And tariffs will be calculated in accordance with the new UK global tariff, except to the extent that they are overridden or superseded by other trade agreements that may have their own tariffs. Customs declarations for most goods could be made in full at January 1st, or could be deferred, kept in the importer's own books, and then reported to HMRC within 6 months. There'll be a new goods vehicle movement service that will come into effect for goods in transit only at first, that can be used for the pre-lodgement of goods before they arrive at the border to hopefully hasten their clearance. This won't be of much consequence to our automobile manufacturer, but there will also be the kind of first tranche of new sanitary and phytosanitary controls, the sorts of controls that David referred to with respect to the pallets that will come into effect then. Further SPS standards will come into effect in April and then again in July. And then by July, full customs declarations will be required for imports, as opposed to using that deferred model that will go into place from the 1st of January. That goods vehicle movement service will apply to imports and exports as well, at port facilities that have implemented the system. And as I mentioned, still further phytosanitary controls at that stage. For exporting from the UK, procedures will all come into force at once at the beginning of the year. So these are full customs declarations, including any sort of safety and security pre-arrival information. And business premises will be able to be authorized as designated export places so that goods can be cleared and consolidated rather than doing so at the border. Border checks won't apply between the Northern Irish and Republic of Ireland border under the current protocol. Some limited checks are supposed to take place between a movement of goods across the Irish Sea, which could pose a host of problems. Not necessarily the greatest of those problems would be that if the UK's checks on goods entering Northern Ireland from Great Britain are insufficient, the EU could fine the UK or bring a case against the UK in the European Court of Justice. And how well all of this goes off, how even-handed it's applied, will determine whether the UK may be in line for complaints from other WTO member states as well. So the second point is how SpeedyCo might deal with export controls. The position there is that there's going to be a lot less change, thankfully. The UK has already implemented, or has always had, the EU use list implemented in UK law, although there are certain UK-specific additions, and that's not set to change. It might be useful to note that the EU is currently undergoing a review process for its dual-use export control regime. And it'll be interesting to see whether the UK has a similar process in the cards after the government finishes with coronavirus and Brexit, whenever that is. Most dual-use controls, though, that are implemented in the UK and the EU are creatures of multilateral agreements, such as Wassenaar and the Missile Technology Control Regime. But technology tends to run ahead of those agreements, and the UK post-Brexit will be somewhat more nimble in its ability to respond to those changes. So for SpeedyCo exporting any kind of dual-use items to the EU, you may think automobile manufacturer, perhaps not much, but there is satellite navigation equipment, perhaps encryption, that sort of thing. Exporting to the EU on the dual-use list will stay the same in practice because the UK has issued an OGEL, an Open General Export License, so that the status quo will remain the same for dual-use items for the most part. The EU has reciprocated and added the UK to the list of countries that can take advantage of General Authorization 1, which allows dual-use items to move from the EU to certain named third countries, which will then include the UK. Presumably, SpeedyCo won't be dealing in military list goods, but just in case it were, maybe it's got a military variant of one of its vehicles. Though military list controls have always been a creature of member state competence, and so the UK military controls are not set to change. The third topic is sanctions. If I could leave you with one message about UK sanctions, is that it will become a distinct and quite different, even from day one, sanctions regime than the EU and the US, creating sort of a third major regime. That wasn't the prevailing mood early in the Brexit discussions. It was that, well, EU sanctions will be translated to UK law, and that will be it. And in substance, that's what the UK has done. It has written its own statutory instruments that kind of replicate the substance of EU sanctions that will come into force at the end of the year. But even their them being anglicized, as the Foreign Commonwealth Office, as it was then called, said they would be, and that's already invited some very early differences in interpretation. The SCO also was aiming to make the new sanctions clearer. Take that as you will, as far as a criticism of EU sanctions, but they want to make them clearer. And in some ways, I think arguably they've already done that. So, for instance, the concept that a sanctioned person controls an entity. In the EU, that's a matter of best practice guidance and member state interpretation. In the UK, it is black and white. How many directors do you have, etc., and that determines whether an entity is controlled. The UK has also changed other aspects of sanctions, such as granting the UK government more discretion in issuing licenses and the ability to issue general licenses like OFAC in the US does, which is a novelty in comparison with EU law. There will also obviously be more sort of medium to long-term divergences in sanctions and, for that matter, export policy. Some of that might be divergences in foreign policy. So the example I always used to give was Russia, that the UK tended to be sort of cracking the whip on Russian sanctions vis-a-vis the EU. I think the mood has perhaps changed in the EU with respect to Russia, but nonetheless, the UK, not sort of tied to the EU anymore, policy may drift. But probably more immediate to that is that the UK will be able to respond more nimbly to foreign policy mandates due to geopolitical changes. So an example of this is the new UK global human rights sanctions regulations that were implemented this summer. The EU, there's a similar regulations in the works in the EU, but it's been in the works for a long time because consensus amongst many nations takes longer. And the UK was able to impose that new set of regulations quite quickly. A final word on sanctions, on enforcement, which isn't strictly Brexit related, but I think it's important to mention that the UK sanctions enforcement has taken a turn more towards American style enforcement than European style enforcement, which I think it's safe to say has been close to non-existent. We'd expect this to continue. The trend is there. The major signpost was this spring's penalty against Standard Chartered Bank for about £20.5 million, which did register in the sanctions world as the UK being really only the second country to impose those sorts of civil penalties, substantial civil penalties for breaches of sanctions. And getting onto sanctions is probably as good a time as ever to hand over to Chris Chapman, who is going to talk about SpeedyCo's financial position vis-a-vis regulatory framework.
Thanks, Jason. Yes, I'm going to give just a flavour of some of the issues Brexit can cause for financial services regulation. And I'm going to do my short session by developing the fact scenario. So let's say SpeedyCo not only offers and builds wonderful luxury cars to customers in the UK and Europe, but also provides other services, including financing arrangements. And it does this through a subsidiary within its group that is fully authorised in the UK to offer these sorts of loans to its customers to help them purchase their cars, and also operates under an EU passport, so that it is also authorised to do that throughout the EEA. Now, I want us to put ourselves in the shoes of SpeedyCo's GC about a month out for Brexit. Let's say it's today, 2nd of December, and she receives a call on her phone, and it's from the chief legal officer at this finance subsidiary within Speedico, and he's very apologetic. He says, look, I'm really sorry. I've got a problem with our Brexit planning. When we planned our Brexit scenarios out about a year and a half ago, look, we were all pretty happy that there was this thing called the transitional permissions regime, because we had understood that would allow us to notify regulators and to continue providing services as we are for a further 3 years. But he says, I'm very embarrassed by this. We've just found out that actually that only works in one direction. That helps European financial services firms coming into the UK, but it doesn't work in the other direction. So there's nothing we can use as a UK financial services firm wanting to trade in Europe to help us do that. So says the problem is, as of the end of this year, we're going to have to stop providing this finance in Europe. So he says, don't worry, I've got a solution. I'm speaking to other providers out in Europe who we can partner with to do this. So the GC hangs up the phone and thinks this is not good, and thinks, well, I must think, does this affect anyone else, any other part of the business? And she thinks, well, maybe I'd better call our insurance partner, because as well as offering finance to its customers, Speedico also offers car insurance, which it provides through a medium-sized German insurer who is authorised in Germany, and also passports throughout Europe and into the UK. So she picks up the phone to her contact at the German insurer, and she says, listen, I'm just calling. I'm sure it'll be okay. I'm just calling to check on your Brexit planning. I mean, presumably you're planning on using this transitional permissions regime, because that works for EU firms, right? And there's a long pause, and the GC's heart starts to sink, and her contact says, look, I'm really sorry. I was actually planning on calling you about this. I've just come out of a meeting. Look, we were planning on using the temporary permissions regime, but the longer time has gone on, the more we've realised actually that that's not quite as convenient as it was all said to be at one time. I mean, it is the case that some firms can simply notify the FCA in the UK, and as a result, they automatically become part of this regime that allows them to continue operating for up to 3 years. But the problem is that at some point in the future, and nobody quite knows when that will be or how soon, the FCA will get in touch with them and ask them to file a full application for UK authorisation. Now, that's a huge process. And once that application is filed and a firm becomes UK authorised, all of a sudden they'll have to start complying with all sorts of new requirements. Now, it is the case that the regulatory regimes are sort of the same, but the more we speak to our lawyers, the more we find out that the UK's interpretation of these things is quite different in some respects than what we're used to here in Germany. So we're only a medium-sized firm. I'm not sure we can afford to become regulated in this way, having to fulfill two very different sorts of requirements. And the position is actually a little bit worse for us, he says, because we would actually need to become dual regulated in the UK. We would also need permission from the PRA, and the PRA will make us submit these applications for authorisation right at the very beginning. So we would have to do it now. And we've had some quotes in, and these things cost hundreds of thousands of pounds just to do the application. So I'm really sorry, but following the end of the year, we're going to stop offering services in the UK. So we'll no longer be able to help you. And as a result of this, I'm going to have to serve notice under our contract under the new Brexit clause we included at our last annual review. So the GC hangs up the phone and leans back in her chair and thinks, goodness me, what an awful day. What other Brexit issues should I be thinking about? Maybe she thinks I should be thinking about intellectual property and data security. And I was going to hand over to Mark to talk to us about that.
Thank you, Chris. From an intellectual property perspective, the GC of Speedico will have been concerned about two particular aspects of the post-Brexit trade deal, if there is one. The most pressing issue will be free movement of components into the United Kingdom and free movement of finished vehicles out of the United Kingdom and into continental Europe. Whilst the UK was a member of the EU, UK businesses have benefited from exhaustion of rights. A product put on the market in one member state by the original manufacturer can be freely sold in another member state. and national intellectual property rights cannot be used to block free movement. From the end of the withdrawal agreement, that's no longer the case. SpeedyCo will need to be clear when it buys components in the European Union that those components are used in the UK, and those components are used in the UK to assemble vehicles, that there's no risk of infringement of UK national patents or other intellectual property rights. This will be an issue to cover in supply agreements. Equally, when exporting vehicles, SpeedyCo will need to be clear that patent licenses and the like, which cover the use of third-party technology in these very sophisticated cars, include a license to use that technology in other EU member states. Secondly, SpeedyCo will be concerned to ensure that it has appropriate protection for its own very clever designs and innovations. The good news is that most intellectual property rights exist independently of the European Union, so the UK's departure will not affect the existence of patents or copyrights that the company holds. There are, however, some intellectual property rights which are creations of the European Union, particularly EU trademarked and EU registered designs. From the 1st of January, SpeedyCo will find that any EU trademarks or EU registered designs it holds will not extend to cover the UK. Instead, SpeedyCo will be pleased to find that it's been granted separate UK national trademark rights and design rights, replicating the protection it had in the UK under the EU trademark and the EU registered design rights. So in a sense, SpeedyCo will be no worse off, though in the long term it will have the burden of maintaining an EU right and a UK right, rather than a single right. There are a number of detailed consequences of this change, which the GC knows will unfold over time, some of which she's aware of and some of which she's not yet aware of. But there is one particular point of note that she's particularly aware of, and that is that the availability of EU design rights can depend on the nationality of the designer. So for key new projects, the GC might well be encouraging the design team to include EU nationals in the team to maximise the prospect of obtaining IP protection in Europe, notwithstanding the fact that all the design work is being done in the UK. Turning now to data protection, SpeedyCo has had a deep dive into data protection issues with the introduction of the GDPR in 2018, which had big implications for the telematics systems it has in its vehicles, which collect data about the vehicles and about the people in the vehicles. Although the GDPR as an EU regulation ceases to apply to the UK from the end of the transition period, the GC has been very relieved to know that the UK has implemented domestic legislation, the GDPR UK, if you like, exactly mirroring the GDPR in the UK, so that from departure from the EU, she will not have to think about a wholesale overhaul of the data protection rules implemented in the run-up to 2018 to comply with the GDPR. The major change in the short term to the data protection rules the company must comply with relate to international transfers of personal data between the UK and the remaining EU member states. Until the end of the withdrawal agreement, personal data can flow freely between the UK and the other EU member states. They're all deemed to have an adequate data protection regime. The UK's position is that nothing changes on the 1st of January, and free movement of personal data from the UK to the EU can continue. The problem is that the remaining member states do not accept the reverse is true. Businesses looking to export personal data from the EU to the UK will need to find another mechanism to permit the data transfer. They need to put the EU standard contractual clauses in place or rely where they can on consent of the individual. For SpeedyCo, which collects data directly from vehicles, it will need to be sure that it has consent to collect data about individuals, and also that it has consent to transfer the data to the UK. It's very likely that SpeedyCo will have to revisit the terms and conditions it has in place with its users. Finally, SpeedyCo has not completely escaped the clutches of the EU GDPR just because the UK left the EU and it's located in the UK. SpeedyCo wants to market more services to people in the EU who bought its cars. If SpeedyCo is deliberately targeting consumers in the EU, it will fall within the EU GDPR with respect to those services. So SpeedyCo will find itself in the position of having to comply with the UK GDPR for its UK operations and the EU GDPR for its activities in targeting users in the EU. If you like, it's a double compliance obligation. Of course, it's also a double compliance obligation for EU-based businesses which incidentally target UK consumers. It seems to be in the interests of both the EU and the UK to find a solution to the data protection issues around the UK's departure, and particularly around international data transfers. The GC of SpeedyCo will be watching this space very carefully over the next few weeks. Which will also be interested in the employment issues. So I now hand over to the employment team.
Thanks very much, Mark. So turning now to employment and mobility issues. The fact pattern is developed again here, and what the position is now is that SpeedyCo has 1,000 employees in the UK, and across the EU we understand that there are an additional 5,000 employees. At least 500 of them are in France and 1,500 in the Republic of Ireland. We're also told that there's a UK-based European Works Council, and that the Works Council agreement is governed by the laws of England and Wales. And on the mobility side, we also are told that SpeedyCo periodically hosts representatives of its overseas parent and posts some of its engineers to work at its European component plants. So I'm going to start just by looking at the Works Council issue before handing over to Liz Stern to focus on all matters global mobility. So on the Works Council front, there are three pressing issues for organisations like SpeedyCo to consider. The first is, will the thresholds for applicability of the European Works Council Directive still apply without the UK workforce? Secondly, should UK employees still be able to participate in a European Works Council? And finally, where should a UK-based European Works Council be moved to? So taking that first issue, from the 1st of January, organisations will no longer be able to count their UK workforce when determining whether the EU Directive on European Works Councils applies. For organisations like SpeedyCo, this shouldn't be a problem because it will still meet the threshold set out in the directive. By way of reminder, the European Works Council Directive will apply where an organisation has more than 1,000 employees across the EEA and has at least two member states with at least 150 employees in each. Here we know those conditions are going to be met by SpeedyCo. It has an additional 5,000 employees across the group, and in France and the Republic of Ireland, that minimum threshold of 150 employees is easily met. So the first issue is clear. The European Works Council Directive will still apply to SpeedyCo. But looking at the second issue, what should happen to the UK workforce? Well, the legal position from the 1st of January is that they aren't required to be included anymore in meetings of the European Works Council. Now, I think this brings with it an important non-legal but critical employee relations issue for SpeedyCo to consider. Should they, despite what the underlying legal position is, allow the UK workforce to voluntarily participate in the European Works Council for good employee relations? Or perhaps, if they don't want to do that, let the UK participants observe what's going on? And that's a question they're going to have to grapple with. And I think history suggests that many organisations will want to include the UK workforce on a voluntary basis. Certainly when the directive first came in and the UK were not a party to it, many UK participants were allowed to participate on a voluntary basis. So I think that will be something for SpeedyCo to think about in terms of its industrial relations. And then the final point, what should an organisation like SpeedyCo do where it's got a UK-based European Works Council? Well, what's clear is from the 1st of January that is not going to be possible any longer. So SpeedyCo will have two choices. Either it proactively selects a new home for its European Works Council and, by reference, a new governing law, or it allows the default rules of the European Works Council directive to apply to determine that question. And the default rule is that the European Works Council will move to the country where SpeedyCo has the most employees within the EEA. Now, that default rule might not bring about it the right result for SpeedyCo, so it is worth, I think, considering proactively now whether to move the home and jurisdiction of the European Works Council. And it's clear trade unions and staff bodies do not like the fact that employers can effectively foreign shop in this way, but the ability to select a new home and governing law for a European Works Council is going to remain unchanged by Brexit. So on that note, I will pass to Liz to talk about mobility issues.
Thank you, Miriam. SmithyCo will need to be thinking about several issues with regard to the movement of individuals who were formerly all part of the EU working for SmithyCo. The first issue that SmithyCo will need to think about is how does it protect the ongoing rights to live and work in the United Kingdom of EU workers that are located in its UK facilities. That issue is relatively straightforward. The UK established an EU settlement scheme by which employees who have arrived in the UK prior to 31 December of this year, 2020, may take advantage of settlement, and settlement provides ultimately indefinite leave to remain. To the extent that SmithyCo's EU workforce in the UK has not yet taken advantage of the EU settlement scheme, they will have until June 30th of 2021, but that is a hard deadline, to register within the settlement scheme and preserve their ongoing rights. That's quite critical. The second issue, however, for SmithyCo will be, what about individuals from the UK that live and work within the EU member states, the EU single market, meaning EU, EEA, and Switzerland? What about their rights? Well, most likely there will be opportunities within each of the member states for UK nationals to do a similar type of registration to preserve their ongoing right to live and work. But the difference in the EU is that the opportunity varies according to the member states' legislation. So it is very important that SmithyCo know, first of all, which of its UK nationals are living and working and need to preserve their rights, and two, that they understand what the framework for preserving their rights beyond 31 December of this year is for those workers. The third issue that SmithyCo will wish to think about is, what about new recruits that show up on our doorstep in the UK? We want to be able to hire the best and the brightest talent. We are accustomed to having an EU flow of great talent, and we don't want to lose it. Well, the UK has set up a new points-based system, the new PBS, to address foreign workers generally, which now include EU workers as of 1st of January. And for those workers that come in from the open market, SmithyCo will typically be looking to a new category under PBS called the skilled worker scheme. Skilled workers will need to be performing duties for an approved sponsor that is allowed to sponsor foreign workers. SmithyCo will want to be sure to be registered and certified as a sponsor. It probably is if it has already worked in the sponsorship regime for EU workers in its core right now, but it needs to confirm that. Provided that it is, then the workers need to attain 70 points in the new PBS system, 50 of which are mandatory and 20 of which really most practically will pertain to salary levels, meeting the salary levels for that occupational classification. Typically, that will be the way that they meet the extra 20 points. So understanding that regime is quite important. It is also possible that Smithy Co. will be looking at graduate visas for students that graduate out of UK universities that it might want to bring over on a student visa called the graduate visa system for a temporary period before it converts workers to the skilled worker 70 points base category. Smithy Co. also may be looking at intra-company transfers that occur after the 1st of January from its affiliated entities in the rest of Europe, for which it can bring them as skilled workers or as ICT, the ongoing category for intra-company transferees. But for a variety of reasons, the skilled worker category may be smoother and easier, in particular because it allows workers to convert to indefinite status, the settled status, after a period of 5 years. I think those are the critical issues for Smithy Co. And the only other point I'll make is that it is very important that Smithy Co. establish a proven compliance framework to ensure that it is tracking which workers are where, that it is prepared for the filings under the new PBS system, and that it is making sure to avoid any gaps or disruption in ongoing work and residency authorization for its work core. Thank you. And with that, I'll turn it over to my partner, Michael Hutchinson.
Okay, so thanks to Liz Miriam for that segment. Turning to environment, one of the things that this Speedy Co does is manufacture, and that means it has emissions. Massive air emissions and probably some water emissions. That means currently it probably has what's called a Part A permission. That Part A permission is issued under the environmental permitting regulations, which themselves are an implementation of EU law. That won't change, nor will any waste law change. So if they produce solid waste, which is quite likely in a car manufacturing business, then that won't change either. So immediately, there isn't a great deal of change. There has, however, been a great deal of speculation about whether or not the United Kingdom will try to undercut its EU competitors going forward in terms of environmental regulation. And we can't actually we don't know the answer to that yet, but what we do have are some signifiers. So for instance, whilst the operating permits, as just discussed, will remain the same, some things are changing. One of the things that's changing from the 1st of January is greenhouse gas emissions and how you regulate them. Currently, this Speedy Co would be required to hold a GHG permit, a greenhouse gas permit, which allows it to emit a certain amount of carbon dioxide and related greenhouse gases. If it fails to do so, it has to account for those by buying credits, allowances within the market, and then that happens every year. You have to show that you've done that. From the beginning of next year, the UK will not be party to the EU emissions trading scheme, which is the biggest trading scheme in the world. The UK is setting its own emissions trading scheme up, and so Speedy Co and businesses like it will need to apply for a greenhouse gas permit under a UK emissions trading scheme. So how does that look by comparison to what would have happened had we remained within the EU? Well, the answer to that is largely it's identical, pretty much identical, except you need to apply for a permit. For now, one of the big things to watch is that the amount of allowances that are available in the market is capped, and that's currently set by the EU. And what's happening from the 1st of January is that that cap will be a mini cap for the UK based on what the UK would have shared within the EU. However, the UK has a statutory obligation now to achieve net zero emissions by 2050. And that means that by 2024, what's going to happen is that the cap will be revisited. In other words, it's highly likely that the cap will be stricter than the EU cap, contrary to the general belief that the UK will be less environmentally rigorous than it currently is under the umbrella of the EU. So I think in that particular respect, the UK will be more rigorous. However, there's a big caveat here, is that most environmental law is EU law. And what the UK is currently doing is putting through a UK Environment Bill to take over that law. And that bill that's going through Parliament is what's called a framework bill. So that means all it does is basically say ministers can come along with statutory instruments, secondary legislation, and provide law for various things, air quality, contaminated land, waste, and whatnot. And we don't know the content of that law. And a lot of what that content will be dependent on where we get to with this trade deal. And even if the UK agrees not only non-regression, which means it won't go back on what it's achieved already, going forward, I suspect that even if we agree that there'll be some objectively assessed forward movement in terms of environment, I suspect there's still a lot of room for the UK through these statutory instruments to soften environmental law. It won't be subject to the same degree of parliamentary scrutiny, and the general belief is, and this may prove to be wrong, but the general belief is this will provide the UK with an opportunity to slightly undercut its competitors. But immediately, aside from the need to get a GHG permit, there will be no change in environmental law. That's basically environment in a nutshell. And now I'm passing on to Stuart, who's going to deal with commercial disputes. Thank you.
Thanks, Michael. Jurisdiction, service, cross-border enforcement are all very technical areas that have been simplified in many respects by our participation in an EU-wide framework, and a framework that the UK is about to leave. So I'm going to look at the impact of that by considering two specific considerations for SpeedyCo. The first is that SpeedyCo is currently engaged in a long-running commercial action in the English courts against a French supplier. How will that be affected by Brexit? The key point here is that as the proceedings were underway before the end of the transition period, they'll be caught by the so-called separation provisions in the withdrawal agreement. This means that the recast Brussels regulation, which is the basis of the EU-wide regime on jurisdiction and enforcement, will continue to apply to SpeedyCo's case, even though judgment won't be given until after the transition period has ended. So assuming SpeedyCo is successful, it can enforce judgment in France just the same way as it could before Brexit. Looking to the future, where proceedings are instituted after the transition period, the Brussels regulation will no longer apply, nor will EU rules on cross-border service. So if SpeedyCo is currently involved in any cross-border dispute, which is getting close to the point where it might wish to issue proceedings, it should think about whether to do that before the end of this year. But coming back to SpeedyCo's ongoing court action, the end of the transition period is unlikely to have any real impact on how the case is conducted. Although EU procedures on cross-border judicial cooperation will no longer be available, in general terms, there are other procedures which are already commonly used in cases involving non-EU parties. So looked at in the round, this change is unlikely to have a material impact on its case, or on SpeedyCo's general preference for having its disputes heard before the English courts. The second consideration for SpeedyCo is that it deals with suppliers and customers across the EU on the basis of contracts governed by English law, and it wants to ensure that disputes can still be heard before the English courts. So what are the key points it needs to bear in mind? Well, first, there's no reason why SpeedyCo shouldn't continue to use English law in its future supply contracts. English contract law is largely unaffected by Brexit and will remain a popular choice for commercial contracts. It's based on the application of well-known principles with an emphasis on upholding the bargain between the parties. And an express choice of English law should still be upheld throughout the EU. Turning to jurisdiction, the English courts will remain a popular forum for resolving international commercial disputes due to the quality and reputation of the judges and the perceived fairness of our court procedures. However, 2 points to note here. First, and as I've mentioned, the UK will cease to be part of the Brussels framework. And second, it's not yet clear that the UK will in future be within the Lugano Convention, which is similar in many respects to the EU framework. The UK has applied to rejoin Lugano in its own right, but it's currently unclear whether and when that will happen. But it does seem clear that the UK will not be a party to Lugano again by the 1st of January, so there will at least be a gap in that coverage. If Lugano isn't available, then the Hague Convention on Choice of Court agreements will become increasingly important for jurisdiction and enforcement between the UK and EU member states. The EU, and therefore indirectly the UK, has been a party to the convention since October 2015, and the UK will be a convention state in its own right from next January. The convention isn't comprehensive, though. It only applies to exclusive jurisdiction agreements. So as a practical measure, SpeedyCo should consider ensuring that its contracts expressly provide for the English courts to have exclusive jurisdiction, rather than using non-exclusive jurisdiction clauses. The convention will mean that a future selection of English exclusive jurisdiction will be respected by courts in the EU and in the small number of other countries where the convention is currently in force. The convention also requires that a judgment given by a court in a convention state, where that state's designated in an exclusive jurisdiction clause, is to be recognised and enforced in another convention state. So that's fine for the future, but what about exclusive English jurisdiction clauses in existing contracts? Any clause that predates 1st of October 2015 is not covered. There's also some uncertainty regarding the status of clauses entered into between that date and when the UK joins in its own right from January. So SpeedyCo should look at its key long-term supply contracts and consider whether the parties should restate the exclusive jurisdiction agreement after the 1st of January to ensure that they're covered. A further consideration is that the EU service regulation will no longer apply. For contracts with an overseas supplier or customer, SpeedyCo should try to include an agent for service clause, so that if a dispute arises, it won't have to serve proceedings out of the jurisdiction. That service out may require the court's permission and is likely to be a less efficient process once the service regulation no longer applies. Finally, what about enforcement? After all, serving proceedings is all well and good. What really matters to SpeedyCo is that it can enforce judgment if the defendant doesn't pay. England will be outside the EU enforcement regime, and even assuming that it's also outside the Lugano regime, that doesn't of course mean that English judgments cannot be enforced in Europe. The Hague Convention will become increasingly important here. But what about where neither Hague nor Lugano apply? English judgments will still be widely enforceable. There's been some talk of old bilateral enforcement treaties with some member states springing back to life. But even leaving that aside, enforcement is generally governed outside any of these frameworks by the domestic law in the country in which SpeedyCo is taking enforcement action. So it's something on which it should take local law advice before embarking on proceedings. So all in all, SpeedyCo should expect the time and cost of enforcement and collection to be higher than previously. I'm now going to hand back to David, who's going to look at competition law and foreign investment reviews.
Thanks, Stuart. So a couple of additional facts. SpeedyCo has a subsidiary, AICO, which is working on the development of autonomous vehicles. SpeedyCo has received an approach from an overseas investor who'd like to take a minority interest in AICO. And SpeedyCo has applied for some grant funding from the UK government for experimental development. First, national security. Last month, the government adopted a long-awaited bill, or published a long-awaited bill, providing for really the most far-reaching changes to the treatment of acquisitions in the UK for several decades. It will introduce mandatory notification requirements relating to acquisitions of so-called qualifying entities, and indeed acquisitions of levels of control on a scale from 15%. So in this particular case, if the minority stake exceeds 15%, because AICO, as the name suggests, is involved in a sensitive sector, once the legislation becomes law, mandatory pre-notification will be required. And this will be backed by criminal penalties and nullity. So as such, that's really at the high watermark of foreign investment rules worldwide. In addition, there'll be a regime that provides for retrospective review of transactions falling outside the scope of the mandatory filing obligation. This will even apply to asset acquisitions and may apply to acquisitions of material influence, which are not otherwise notifiable. So again, quite a draconian regime. There's a provision for retrospective validation of transactions and for voluntary notification to provide some legal certainty. This isn't yet enforced, but there is an element of transaction risk for transactions currently pending because of an ability to look back for 6 months once the government to look back for 6 months once the new regime comes into force. The government's expecting a lot of filings, about 1,000 or more per year, and it will be handled by a new unit separate from the Competition Markets Authority. As regards the CMA, it will continue to have parallel jurisdiction. The CMA has additional resources. It's very keen to play an active role in international cases. It has indicated that it will show additional flexibility in the application of some of its procedural rules. It's published some very practical guidance on the arrangements for the end of the transition period. And there's also a separate review currently going on with a view to modernisation of competition law. I think we'll see developments in the area of consumer protection, possibly individual responsibility, and certainly legislation in the area of large technology companies. Finally, a word on state subsidies. The concern, as I mentioned, is that the UK may in the future gain an unfair advantage in a sense against its continental jurisdictions. Not an area where the UK has historically been terribly active. It's ironic that this is now centre stage in the negotiations. If there is an FTA, a free trade agreement, there will be probably an agreement providing for an enforcement body, a dispute resolution mechanism, a retaliation mechanism, and review in the event of a failure to comply. What I think is less appreciated is that the current rules will continue to apply to existing aid, that is aid granted before the end of this year, until 2024. So aid granted to AICO now before the end of the year may be subject to review by the European Commission. Otherwise, it may be subject to a new regime. Just a footnote to this also is that the EU has published this year a proposed or a consultation document on the review of foreign subsidies. This effectively gives it a new weapon. I think if the UK, for example, doesn't agree to a common state aid framework, then the EU will have a new weapon with which to respond to the UK. So I think the UK is set to see some changes, some significant changes in competition law and certainly foreign investment policy over the next over the coming period. Just in conclusion, I'm being quite quick because we're up against the time limits now. This really concludes the case study. I think a lot is quite clear and certainly very much remains unclear pending the outcome of the current negotiations. It's of course theoretically possible that the government could continue discussing these issues with the Commission after the end of the transition period, but that would be subject to, we would fall back on World Trade Organization rules at that point. We will be monitoring those developments closely. We'll be publishing more commentary on the 1000 site. Do consult the Brexit Spotlight on that webpage, where there'll be additional information becoming available over the next 100 days and beyond. If you have any questions, there's a link here that you could send them to. We'll be happy to try to respond to them. finally just like to thank you for participating and to thank all the speakers. Thanks very much. Goodbye.